I'm here today to talk about the law and land and the prospects for redistribution. I want to take apart every single one of those words and embark on a long and perhaps boring content analysis, so I'm not going to do that. But what I am going to do is suggest to you really two things. The first is that the law in South Africa is, for better or worse, the vehicle through which the political settlement that was achieved at the end of apartheid decided to structure social change and redistribution. That choice has been made. It can be unmade. There is always the possibility that the choice can be unmade through a different kind of political system being brought into force. But for so long as we have this particular political system, the aspirations through which, the processes through which we seek to achieve redistribution of land and property and wealth in this country are going to be mediated through law. Because at the end of apartheid we adopted a constitutional settlement which, for better or worse, placed law and legal forms at the center of what it is to act politically in this country. Now, let me not be misunderstood. It's not the only thing that's important. It may not, given the context, be the most important thing. Law and legal regulation and lawyers may not be the most, lawyers in particular, will seldom be the most important political actors. But in every walk of life, in every form of political change or political action you see in post-apartheid South Africa, the law is there and it's playing a prominent role. You know that the economic freedom fighters like to go to court. They like to march as well. I recently completed a stint as an acting judge in Johannesburg, and there were a couple of cases I heard that had political interest. And every time one of the cases had the interest of major political parties, including the EFF, a mini stadium would go up outside. There would be a large gathering of people. It would be very loud. And political parties, including, for example, the economic freedom fighters, they're not the only example, of course, they're just the example I'm giving, couple legal activism, asking courts to do things or to refrain from doing things, with direct action on the streets. And so one doesn't exclude the other, but in every walk of life, from high political decisions about what Parliament can and can't do, whether the President can employ this or that minister, whether the President can discontinue or extend the COVID grant, from sort of high-level policy decisions like that to the everyday concerns of ordinary people who go out onto the street to protest for particular forms of change. Law is there, and it's not something we can get away from. And the reason why I emphasize that as my first point is that there is a tradition on the left, and if we're talking about redistribution, we're talking about left-wing politics. That's what the right likes to keep things as they are, or to distribute resources along certain well-known racial and gender lines, but mostly to keep resources concentrated at a particular end of society. The left wants to redistribute. The left wants to achieve economic and social equality. And so if we're talking about redistribution, or any redistribution that you want to call social justice, we're talking about left-wing politics. And the reason why it's important to emphasize the centrality of law and legal forms to political change in this country since the adoption of the Constitution, particularly since the adoption of the Constitution, because of course the tradition of legal activism goes back way before then. But the reason why it's important to emphasize the centrality of law and legal forms is because the left, in large part, has traditionally rejected it. Marx was not keen on saying much about law at all, but your basic cod Marxism is that law doesn't really do anything. It's part of the superstructure. Economic relationships of production are what determine the structure of society, and laws are things that bourgeois lawyers make up to try and trick working class people into thinking that the fundamentally unjust relationships are just. And if you believe that, as I don't, but if you believe that, I wouldn't be a particularly successful lawyer if I did think that, but maybe I'm not, but anyway, we'll get there. If you believe that, then it's very easy to reject law and lawyers. If you are a left-wing activist, somebody who's seeking redistribution, and you're a good Marxist, or at least let's call them classical Marxists. There are lots of abusive terms for Marxists, often made up by other Marxists. But if you are a classical Marxist, then obviously it's very easy to take Marx's fairly sparse comments about law and the theory of base and superstructure and reject law and legal action as reflective of change that's going on elsewhere, not causative, not something that can actually cause social change. If you believe that, then there is no point in engaging in any form of political action in this country beyond the overthrow of the existing state. And you may well believe that, and good luck to you if you do. I don't. So what I'm trying to emphasize as a first point is that law matters. Law matters because at the end of apartheid, the political settlement decided to put it through the Constitution at the center of political life. And you have a choice. You either see this, if you're interested in redistribution, which is the other thing I'm supposed to be talking about, and don't worry, I'll get there. But if you're interested in redistribution, you have a choice. You can either reject the whole thing as some sort of ideological trick, or you can ask whether law whether the Constitution and the law can, in some non-trivial sense, make a difference, whether it can drive social change. And what I'm going to suggest to you is that in incomplete, you might think perhaps limited ways, legal changes, legal activism since the end of apartheid has brought about a modest amount of redistribution in property rights and in ideas about land and property, and that the Constitution and the law remain resources that ought to be available and exploited by people seeking redistribution. Now, notice how carefully I've hemmed in those claims. I haven't said, don't you worry, sit down, I'm a lawyer, I'll sort it out for you. I haven't said, don't you worry, sit down, the Constitution will make all well if you can only just wait a little while for it to do so. That's not what I'm saying. Nor am I suggesting that the law is able, in and of itself, that legal activism in and of itself, divorced from any other form of political activism, is enough to bring about redistribution of land and wealth and power in this country. What I'm saying is that it's a limited resource that can, in specific circumstances, bring about pro-poor change. And once we know what that potentiality is, we can start to consider how that potentiality, that ability of the law to achieve concrete social change fits in with a wide variety of other things we might be doing politically in order to redress the injustices of the past, to redistribute wealth and power in this country, to combat the insidious legacy of apartheid. Once we know what the potentiality is, we can start to integrate law into a broader strategy. And so far as, I mean, you'll be familiar with a wide variety of legal activism that's taken place against after the end of apartheid. There's a wide variety of cases that have been celebrated. For example, the Treatment Action Campaign case, which and the activism that widened access to antiretroviral drugs, initially for HIV-positive pregnant and nursing mothers, and then later for a broader class of people who are HIV positive. There are many, many other examples. What I try to do in my book, and what I want to address briefly today, is the second part of what I've been asked to talk about, the land and redistribution. And I want to suggest to you that as a result of legal activism pursued by a wide variety of people and institutions, not always, in fact, often not, coordinating with each other, small changes have taken place. Fairly big legal changes, but fairly small social changes have followed on from those big legal changes that have yet to be developed and exploited as effectively as they could be. What do I mean by that? Well, what I mean is that in the context of access to urban land, the law, insofar as it applied at the end of apartheid, has radically altered. At the end of apartheid, evictions of unlawful occupiers from land that they had no right to live on, that's the definition of an unlawful occupier, were very, very easy to achieve. In some circumstances, you didn't even need to go to court and get a court order at the end of apartheid. Immediately before the adoption of the constitution, the owner was king. Now, socially situated, what does that mean? Well, we all know that patterns of ownership rights have been dictated by colonialism and apartheid. And we know that by increasing the rights and powers of owners of property, the law under colonialism and as entrenched and ossified under apartheid, entrenched racist patterns of property distribution. And one of the ideological tricks of the law under apartheid, and I don't say that the law is incapable of being used ideologically to trick or to try and implement an ideological trick. I just say that's not all the law is. But at the end, one of the ideological tricks played under apartheid is that ownership, the concept of ownership, and the rights associated with ownership of property were expressed as race and class neutral. An owner was a class of person that stood outside society. Anyone technically could be an owner under the common law. The apartheid state regulated that quite heavily, but insofar as the common law was concerned, if you took away the way that the apartheid state legislated property relations, technically anyone could be an owner. And since the end of apartheid, the common law of property has re-emerged as this morally and politically neutral idea of how to entertain or how to structure property relationships in this country. Ownership is complete and utter domination over the particular piece of property that you own. Claims of others to use that property are excluded in favor of the owner. And very often apartheid implemented itself through the concept of ownership by regulating who could be an owner and who couldn't. And once the apartheid edifice was taken away, what you were left with is racist patterns of property ownership. Most, in fact, an overwhelming majority of people at the end of apartheid who owned land were and continue to be white. And the overwhelming majority of black people didn't have ownership rights, and to some extent, and to a great extent, still don't. But the category of owner has been traditionally extremely difficult to criticize. Ownership is seen as a sort of a neutral legal concept. Everybody kind of wants to be an owner, and nobody is prepared to problematize what it is to be an owner. But if ownership means domination over property to the exclusion of all others, and if only a tiny minority of us are owners, then we do need to problematize what ownership is. Either that, or we need to give everybody enough money to become owners. But even if we did that, tomorrow somebody would fall on hard times, have to sell their property to someone else, and inequality would begin to replicate itself again. So what has happened to change all of that? Well, what I want to suggest to you is that over the last 20 to 25 years, we have begun to unpick what it means to be a common law owner and the assumptions that underlie the legal protection of ownership in this country. If I go back to the example of unlawful occupiers, people who live on land that they don't own and have no other common law right to occupy. Under apartheid, very easy to evict them. Sometimes you didn't even need a court order. Under the common law, you did need a court order. It was just very easy to get one. But since the end of apartheid, under the Constitution, no one may be evicted from their home without an order of court made after considering all the relevant circumstances. And through a series of cases from Government of the Republic of South Africa versus Grootboom to most recently a case called Occupiers Berea, a system of restraints on ownership powers has developed, which means that an owner can't just evict someone whenever he or she feels like it, that evictions that lead to homelessness are generally unlawful, that eviction orders are very difficult to get where they would otherwise lead to homelessness, because an owner generally has to prove that alternative accommodation is available. And very often, as we know, because of the way land is distributed in this country, alternative accommodation isn't available. Now, those are all very nice abstract principles. Let me give you a concrete example. Because of the restrictions on eviction in this country, places like Ekanana, which many of you will have heard of, in Durban, become possible. Ekanana started as a land occupation by people who were evicted from backyard shacks in the neighbouring Mayfield area of Durban because they couldn't afford the rent. They couldn't afford the rent. A lot of the occupation took place just before COVID, but they couldn't afford the rent because property owners had summarily decided to increase rents. Also, they'd lived in backyard shacks in other informal settlements, and state housing policy required that when the informal settlement was upgraded, an area or a plot of land that accommodated 6 or 7 families would in future only be able to accommodate 1, because the backyard shacks would be unlawful in the upgraded informal settlement. So for all of those reasons, there were massive push factors out of the local informal settlements and out of backyard shacks. And what you had was the Ekanana land occupation. People had to go somewhere. They saw an open piece of land. They built their shacks on it. Now, if all of those legal developments that I've just told you about in very, very, very broad outline hadn't taken place, then the state would have been entitled to march into Ekanana and burn it to the ground, which is, to be fair, what they did on a number of occasions. But that would have been where the story ended, because there would have been no way, no restraint on the use of the state's power to continually evict the occupiers. And the story of Ekanana is that every time the original occupiers had their shacks destroyed, they rebuilt. They were able then to get access to legal assistance, primarily from Abiklali Basiam Jandolo, later from the Socioeconomic Rights Institute, which briefed me to act on their behalf. And the law was able to put up a shield around Ekanana that stopped repeated unlawful evictions, precisely because they could be labelled as unlawful, and under apartheid they couldn't be labelled as unlawful. And then required the state to bring a formal eviction application, in which the state had to demonstrate that alternative accommodation could be made available. Not sure that has been demonstrated yet, but the state has taken 2 to 3 years to demonstrate it. And while that has been happening, the evictions at Ekanana have, in the beginning they didn't completely stop, but the level of eviction activity in the settlement has reduced a great deal. Ekanana is there, it is a site of struggle. Now, we know that it's a site of struggle because the state's going in and doing all sorts of other things. It's killing people. Not the state directly, but we know more or less where the assassinations are coming from. The law hasn't put up this perfect shield around Ekanana, but it has, through requiring the state to prove that an eviction would not lead to homelessness before Ekanana can be removed, sustained Ekanana as a site of struggle, as a place of possibility. And of course, once that's happened, then other things become possible. Then forms of political action and political activity become possible. Now, those forms of political activity and political action aren't risk-free. We know that. It's not as if because the evictions have stopped or are rare and generally don't have the effect of destroying the entire settlement, that everything is fine. That's not the point. But the point is that law has been able to provide a breathing space for the Ekanana community to pursue its struggle in all its various forms, and with all of the setbacks and struggles and risks that have attended upon that. And so that's one fact-based example of how law is able to provide a shield to people who've gone in and redistributed the land themselves. They've gone in because they have nowhere else to go, and they've set up property. They've set up land on property they don't own because they have no other choice. And the law has been able to preserve Ekanana as a site of struggle, not as a site of perfection, not as a site of a completely rosy reflection of what the Constitution is supposed to be, but it's given the people of Ekanana a foothold, and it's a foothold they can do something with, and as many of you know, have been able to do something with. Elsewhere in the book, I talk about how a system of rental housing tribunals has been set up in order to mediate relationships between landlords and tenants, and how decisions of the Constitutional Court have recently established that landlords and tenants have a duty to act fairly towards each other. Now, you may think that that's what the law always said, but that isn't what the law always said. At common law, an owner is only required to tolerate a tenant on his or her property for so long as a contract requires them to do so. And the rights that the contract will give to the tenant depends on the conditions in which the contract was entered into. And we know that rental housing arrangements are always inherently unequal. We know that if a very few people own a great deal of property, and there are a lot of people who need to rent the property to live, then the conditions of the market will favour the owners at the expense of tenants. And so the conditions of contract will be unfavourable to tenants. Tenants will agree unfair contracts all the time. And what a series of legal reforms in the last 10, 15, 20 years has done is reshape the terrain on which contracts can be made, and has required landlord and tenant contracts to be fair. A particular example from my own practice relates to a situation in which a group of people in the inner city of Johannesburg contracted to live in a bunch of fairly dilapidated houses in the centre of town. And they asked their landlord to upgrade the houses. And the landlord said, no, I'm not going to upgrade the houses. You live in the conditions that I've put you in, and the conditions were fairly awful. Holes in the roof, holes in the floor, very dangerous electricity connections. And then the tenant said, well, we don't think that this property is worth what we're paying for it, so we're going to remit our rent. We're going to cut our rent down, and we're only going to pay you this much instead of this much until you fix the property. Now, it would have been very difficult at common law to sustain a claim like that. The rules about when you can remit rent inherently favour property owners. But the regime set up by the Rental Housing Act and the Constitutional Court decisions that say landlords and tenants have to act fairly towards each other have completely changed the terrain on which arguments like that can take place. And in this particular case, the owner decided he was going to end the argument by trying to evict the occupiers. The occupiers, the tenants, immediately complained to the Rental Housing Tribunal and have kept the owner, and that has kept the owner tied up in a debate at the Rental Housing Tribunal for 2 or 3 years about the extent to which he has or hasn't properly upgraded the property. And all the time, the tenants are paying the lower rent and not the higher rent. None of that would have been possible without post-apartheid legal reform. And what does it do? Well, it doesn't immediately redistribute property and make everybody happy tomorrow. It creates a site of struggle. It creates a situation in which usually very unequal parties, individuals, can fight or can pursue their interests, which are often conflicting, on a more equal basis. In the old days, remember, the owner wouldn't have been required to tolerate a remission of rent, and he would have been able to evict in some cases without a court order. Now he can't evict, and there's a debate in the Rental Housing Tribunal about whether he should have to tolerate the remission of rent, how long he should have to tolerate it for, and to what extent he should be upgrading the property for the purposes and for the use of his tenants. Again, a site of struggle, a place where argument is possible, where before there was just no struggle. Owner would win every time. Last example. Under the rules that applied before the Constitution was adopted, if you fell 1 cent behind with your mortgage bond, a bank could call up the entire outstanding debt and sell your house out from underneath you. Those are the rules of the common law before the end of apartheid. Through a series of cases in the last 20 to 25 years, that has changed. Now, a bank, if it wants to take a house away from you because you haven't paid your mortgage bond, has to demonstrate that it would be fair and proportional to do so. These are not ideas known to the common law. They certainly weren't ideas that were known to the law generally before the Constitution was promulgated. So what does it have to show? It has to show that you're far enough behind with your bond in order to conclude that rehabilitation of the debt is unlikely or virtually impossible. It has to show that you've been given every opportunity to refer your case to a credit ombudsman or a debt counsellor. It has to show ultimately that its interest in collecting the debt outweighs your interest in remaining owner of your home. Now, that kind of balancing exercise, which comes straight out of a decision of the Constitutional Court, Jafta and Schoeman, and then later there was another decision called Gondwana versus Steco Development. What does that balancing exercise create? I'm tempted to say it with me, but I'm not. A site of struggle. That balancing exercise, the legal creation of that space where we have to have a debate about whether or not it's okay to take the ownership of your home away from you, even though you've fallen behind with your repayments, creates a site of struggle, creates a point of debate where you can start talking about fairness. And there are many examples of cases where banks have been required to revise their debt collection policies in order to be fairer and more equitable and more proportionate. Banks are now much more leery of executing against homeowners at the first opportunity. They're much more likely to negotiate a restructured debt. And the days of people being put out of their homes because they are, for example, there's a case called Absa Bank versus Nsani, where the bank claimed the right to turn a man out of his township house because he was 18 rand and 47 cents behind with his repayments. Nobody would dream of trying to do that now. And I know because I've been in that position myself as an acting judge. Judges are alive to how far behind individuals are with their debt repayments. In one of the cases that I did, we were able to prove that a bank had sold a property out from underneath a family of 7 in Soweto in circumstances where they had completely repaid everything that they'd owed. And what the bank had been doing is adding compound interest and legal fees and all sorts of other extraneous fees to the debt, and that had been allowing them to continue to represent that the family was behind with its repayments. Those kinds of debates would not have been possible. Those kinds of cases would not have been possible if there hadn't have been a decision of the Constitutional Court that says, well, it's not enough that you're behind with your debt. Execution has to be fair and proportionate. So where does this leave us all? It doesn't leave us all in the sunlit uplands of the revolution, unfortunately. It doesn't leave us all with perfectly redistributed land with a just South Africa. What it leaves us with, and what it leaves ordinary people who plan their lives and pursue their aspirations every day with, is an opportunity to struggle, a site with which to engage those who before would have wielded overwhelming power over them. That is what the law promises. It doesn't promise redistribution per se. It promises the possibility of creating spaces in which people can redistribute for themselves. And that is what I have to say, probably well in excess of 20 minutes. But thank you.